So one of the advantages of representing breweries, and maybe it's an advantage, maybe it's a disadvantage, because I often get paid in beer, which is great, but I can't pay my rent in beer, or my mortgage in beer, so I do have to find clients willing to pay me in cash as well, but it does help to fill up the beer cellar. My name is Jeff Glazer. I am an assistant clinical professor at the University of Wisconsin Law School, and in particular I teach for the UW Law and Entrepreneurship Clinic. Brewing laws are a patchwork across the United States, so every state is different, and indeed every municipality can be very different. So knowing, being able to navigate that regulatory maze is really difficult whenever you're dealing with alcohol. Chapter 125 of the Wisconsin statutes is where all of the brewing laws are held. But it's not just the Wisconsin statutes that are relevant. There's an entire federal framework for brewing laws. And then that's just getting the brewery started. That's not to mention labeling regulations and distribution issues. So it really involves a pretty broad understanding of entity structure and business formation, but also contract work. And then once the brewery is up and running, a lot of the issues relate around employment issues, and trademarks is a big issue in craft brewing. The fundamental basis for alcohol regulation in this country is the three-tier system. And what that means is that each tier of the manufacturing and distribution process is kept separate and distinct. So manufacturers can't distribute, distributors can't retail, retailers can't distribute or manufacture. The default rule is that if you are in one of those tiers, that you can't do the other two tiers. That's the default rule. There are a lot of exceptions. In its broadest sense, a brewery is a manufacturing facility, right? Breweries manufacture beer, just like Nike manufactures shoes, just like Apple manufactures computers, breweries manufacture beer. And the general rule with breweries is that they can't distribute and that they can't sell at retail. Now, of course, breweries have tap rooms. That's an exception to the three-tier system, because breweries in that case are selling directly to consumers. A brew pub, as distinguished from a brewery, is a brewery that is also a restaurant. And the reason why we make that distinction is because, at least in Wisconsin's laws, breweries can only sell beer. They can't sell anything else. They can't sell wine, they can't sell liquor, they can't sell any other alcoholic product. So if you want to run a restaurant where you're also selling wine and spirits and cocktails, you need to have what's called a Class B license here in the state of Wisconsin. The laws prohibit breweries from owning Class B licenses. So they created this new class of breweries that can hold Class B licenses and be restaurants. And those are brew pubs. And there is a different set of rules that apply to brew pubs because they hold that Class B license and because they are a restaurant that don't apply to breweries, and vice versa. As you go down the three-tier system from manufacturing to distribution to retail, it sort of mimics the regulatory coverage of federal to state to local, which is to say that manufacturers are largely governed by federal law, and states, by and large, just say, if you have a brewer's permit, you can be a brewer. And the brewer's permit is issued by, or the brewer's notice, I should say, is what it's called, is issued by the federal government. And then the state says, if you have one of those and you follow a few other rules, you're fine. Distributors, on the other hand, are governed almost entirely by state law. Very little federal law that applies to distributors. And then at the other end are retailers, who are almost entirely governed by local law. The state sets up some rules around the kinds of ordinances that the municipalities can pass, or that the municipalities can implement. But by and large, retailing is governed by local municipal law.